I am now going to hand over to Liberty. Thankfully, both our speakers are sitting beside me, so I don't have one of those scary moments where I have to find you out in the ether. Good morning to you, Liberty.
Thanks very much, David, and good morning to everyone in the UK, and just in case anyone's in China, good afternoon. So my name is Liberty Timewell. I'm the Senior Policy Advisor based in the UK, working on China for the Intellectual Property Office. So the Intellectual Property Office is part of Business Innovation and Skills, Vince Cable's department, and I work predominantly on UK-China relationship. So I'm one of the 4 people that make up the China team, with the other 3 based in the British Embassy, Beijing, including our attaché, Tom Duke. So if I could go to the next slide. So what I'd like to do briefly this morning is to set out a bit of what the China team for the IPO do in the UK and in China, and then to give a bit of an overview of the Chinese IP environment before handing over to Tom this morning. So I have sort of 2 key parts of my remit within the IPO. So firstly, I focus on business support and outreach. So one of the key things that we want to do is to enable British businesses to have the right information, tools, and the opportunity to interact with the Chinese IP system so that they can operate effectively and work out in China, raising money for the UK. So we do this in a number of ways. Our attaché out in Beijing and our business support officer provide free one-to-one advice for businesses, for UK businesses who are either thinking of going to China or who are already operating out there. And one of the trends that we're seeing in those, in that advice that we're giving out, or the support that we're giving out, is that people are coming before they have a problem, and that's something we'd really like to encourage. So it's a positive trend to see people preempting problems and thinking about mitigating strategies for IP as opposed to only coming when they have a problem. We also try and give out a lot of information. So you can see on the slide there, there's a snapshot of our newsletter. So that goes out monthly and has an update on all of the exciting trends and things that are happening in the Chinese IP system. So if it can be highlighted just at top right. We also have on our website a number of fact sheets which give an overview of the Chinese IP system and also go into specific detail on some of the topics that we hear British businesses are most concerned about. So whether that's IP and architecture, or trade protection at trade fairs, or trade secrets, there's a whole range up there. So I do recommend that you take a look. As part of our business outreach, we also organised the UK-China IP Symposium, which was in Beijing last year and will be in the UK this year. That's an opportunity really for British businesses and Chinese businesses to take the time to have an open and public dialogue with the IP agencies from both countries and to discuss their main policy issues and the current trends that are emerging and plans going forward for both IP systems. And that middle picture there you can see is on stage in Hangzhou. It was the signing of the CBBC and Alibaba MOU, which the IPO helped to create. And I think we'll come on to that a bit later when we're talking about internet takedowns. So that's an overview of the business support and outreach that we do. And the second key area of my work is policy, cooperation and projects. So the UK has a very strong relationship with the Chinese IP agencies, and we've often been noted to be the primary partner for IP cooperation for China. So what that means is that within China there's a fast pace of reform, there's a lot happening, and we're always keen to be involved. I'll talk a bit in a moment about that. So we have a key relationship and cooperation activities with the State Intellectual Property Office, the China Trademark Office, the Trademark Review Adjudication Board, and all of the agencies that deal with the key elements of IP. We engage in technical exchanges with them and share information about best practice so that going forward UK businesses' interests are reflected in that dialogue. We also organise exchanges between the judiciary, and we have a strong dialogue and cooperation in that field. And going forward, I think people realise that IP criminal networks are now cross-border. So one of the things that we also try to do is link up our enforcement agencies to make sure that people those networks, we can share information on them between countries. So next I'd like to just give an overview of the Chinese IP system as we see it from government and from London, but also from sitting in Beijing. So the first thing to note is that China's IP system has really developed incredibly fast. So their first IP law was passed in 1983, so they've really not had that long to develop this system, and compared to the UK, which has hundreds of years of having an IP framework for that to be sort of involved in the UK psyche, China's IP system is fairly fresh. So one of the things that we can see from that, though, is that the pace of change is incredible. So at the moment, China has a number of reforms in process. Last year, they fully overhauled the China trademark law, and we hope to see a lot of benefits to British businesses going forward. In the next couple of years, the patent law will be reformed, and we hope that that will be enforceable around 2016. SIPO recently published the most recent version of that, and again, we hope that that will bring a lot of benefits to UK businesses. And the copyright law, which Tom will go into some more details of how this affects British businesses, we also hope in the next few years those changes will come into force. So one of the things you can see from that is how much opportunity there is for the UK to be involved, and we always take the issues that you raise or that British businesses raise with us, we feed into our policy dialogue, and we feed them into the Chinese government. So when they're reforming, that's our opportunity to feed in and let them know what is important to UK businesses. So on the slide there, one of the other things to note about the Chinese IP system is the sheer size and scale. So you can see there that there were 2.3 million trademark applications in 2014. It really is an order of magnitude that surpasses anything we have, anything other countries are looking at. So that's more than the total number of trademark applications across the whole of Europe last year.
And Liberty, are they mostly Chinese companies, or are foreign companies, filing a majority of those, or a proportion of those, or do you know that off the top here?
So one of the exciting things about looking at this is that 90% of those 2.3 million trademarks are actually domestic applicants. So you can really see that they're driving the change in China, and it's that willingness or desire to protect their domestic companies and innovation, which is prompting the Chinese government to implement all these changes and to make the difference. For a bit of context, UK applications represent 7,000 within that 2.3 million. So always good to remember the place of the UK in the context of China.
Still, though, each one of those 7,000 is important for a UK company. So
it's very important for each individual person that's registered them. So yeah, as you can see there, the size and scale of China and their IP system is massive. But the one thing that we want people to take away from this is that it is possible to protect and enforce your IP in China, but you do have to engage with the system, and that you can see there that they have a fully functioning IP system, and finally that the UK government and our IP attaché in China are here to help. So that's my introduction.
Terrific. Well, I think that segues very nicely into it is possible to protect and enforce your IP in China, and we hand over here to Tom, who does exactly that. I would say don't be softly spoken. Some people are having some sound issues, not by me. Liberty, you're very softly spoken. I don't have such a problem, but Tom, please do feel free to belt into the microphone there.
Right, David. Well, I'll do my best, both to speak loudly and to explain a bit about how it's possible to protect and enforce. Before we start, I better just introduce myself. My name's Tom Carver, as David said. I work at Ragg, Lawrence, Graham & Co., which is a UK headquartered law firm, but we have an office in Guangzhou in South China, which I was the head of for 3 years, doing largely intellectual property, a bit of other FDI type work, but mainly intellectual property. So I spent 3 years seeing the common problems, helping to fix them, helping clients to enforce, helping to file. So I have a fairly significant experience of the system. So we have an agenda here. I'm going to give a quick overview of the various different rights that are available in China. which are largely correspond to what's available in the UK. So if you are up on your UK intellectual property, then the first half will be very easy for you. And then the second half, we're going to talk a little bit about the enforcement options and various different ways you can go about protecting your IP in China. So first slide, David's ahead of me already, good. So what are the rights available? So firstly, on the slide before you would have seen there are patents, there are trademarks, there's copyright. So first things first, patents. In Europe, you might be aware that we have something called a patent and we have something called a design right. And there are various different types of design right. There's registered, unregistered, but they all fall under the heading of design right. In China, they have a slightly different system. They have 3 different types of patent. But what they call a design patent is basically the same as what we in Europe would call a design right. What we in Europe call a patent, in China is referred to as an invention patent. So those are the 2 extremes of the sort of patent types. An invention patent will cover an invention. So if you come up with a new technology, in the one end it's the big pharma inventing a new drug, at another end it's just a new type of widget. If it's a new bit of technology, you get a patent. If you have one of these, you'll be familiar with how they work. The next layer down, I guess, is a utility model patent. We do not have utility model patents in the UK. They do have them in Germany, but not in the UK. So often I find that English companies don't know much about these. And they're sort of a halfway house between a design patent and an invention patent. An invention patent has got to be something technical, got to be innovative, it's quite a high bar. A design patent is purely a design. It's just the shape, the pattern of an object. And a utility model sort of lies somewhere in between. It's got to have a technical solution, but it's not quite as high a bar as an invention patent. So this is something to think about when you're talking to your patent attorney about what rights to file in China. Ask them about utility models, because an English patent attorney might not always suggest that to you of their own accord, because, as I say, we don't have them in England.
Are UK companies, because they don't have the corresponding thing here, are they a little bit nervous about this sort of concept they've never heard of? And is that an error in your opinion, or is this a real viable option?
I think they're not nervous. I think they just, a lot of English patent attorneys just don't think about it. It's just purely because we don't have them in England. And there's nothing to be nervous of. They're quite good, useful things. If we go on to the next slide.
Sure. Well, I think we have a poll that we're going to launch as we get going, and this is the first. Have you exhibited or sold your products in China yet? And we've just got a couple of answers. Yes, and we have had no IP issues, and yes, and we have had IP issues. No, and other. So this will help Tom understand a little bit about the demographic of our listeners today, and just help him pitch his words accordingly, I think. So we'll just give it another couple of seconds. Yeah, perhaps you can.
So I was talking about the usefulness of utility model patents. You can see on the next slide. Can we go on to the next slide?
Yeah, I'm just going to close and
share we need to wait.
our
Okay,
results.
sorry.
Yeah, we'll just give it a second.
I can keep talking. Utility model patents are not examined by the patent office before they're granted. So this means they're very quick to grant. An invention patent has to be examined by a patent examiner at the patent office, and this means it takes time to grant. There'll be questions, there'll be what we call office actions, there'll be a back and forth between the patent office and the applicant, and it can take, say, 3, 4, 5 years, something like this, for an invention patent to be granted. As opposed to that, a utility model is not examined, so it's very fast to be granted. So you can actually patent the same. You can apply for a utility model and an invention patent on the same technical advance at the same time. Your utility model will be granted in a year, and you can then start to enforce that after that year while you're waiting for your invention patent to be granted. Then when your invention patent comes to grant, you withdraw your utility patent because then, so you don't, you're not allowed to have 2 patents on the same thing. To avoid double patenting, you withdraw your utility patent and you carry on with your invention patent. So they're quite useful for plugging a gap pre-grant of an invention patent.
Okay, well that's extremely interesting and valuable for our listeners today. Just a little bit of thought there. So 50% of people are yet to exhibit or sell their products in China. So I'll just give you some perspective there, Tom, as you go forward.
And then we've had some yes and no IP issues. Yes, we've had IP issues. So the 50% that have not yet exhibited, that's good. What I would advise you to do before you exhibit is apply for your IP protection in China. Going back to what I was saying about the examination process, utility models and design patents are not examined. Now this works for you when you're applying because they're quick to be granted, but it works against you if someone unscrupulously applies for a design or a utility model for your product in China. And they are allowed to do that. The application is not examined, so if you've gone to China, you've exhibited, someone has been around looking at your products, they've thought, oh, that's a good product, gone away, filed an application at the China Patent Office, and then this is going to be a problem for you, because when you come to file your design right in China, you'll find that someone has got there first.
So they don't have to demonstrate any real connection or ownership of this product. I mean, it's still first to file ultimately?
No, so then you will be able to, if it's still within the priority period for your rights and you can apply a bit later on, you should be able to prove that this was yours. Contrary to trademarks, we'll come on to trademarks in a bit. For patents, you should be able to get your rights back, but it will cause trouble, cost you money, generally make a mess of your plans. So it's best to file, get your ducks in a row before you go. So that's a little, I think we'd sort of finished on that slide really. If we move on to the next slide, just things to be careful of. This is a very particular thing for a patent, for an invention patent. An invention patent, the scope of your claim is expressed in words. Okay, a patent it'll have diagrams, it'll have pictures, it'll have a description, but the important bit of an invention patent is what we call the claims. And the claims define the scope of your protection, they define your invention, they define what you can protect and what you claim. And so it's very language dependent. Patent lawyers spend a lot of time thinking about very precise wording to claim your invention. And it's a very difficult thing to do because, of course, when you're making a claim, by definition, you're describing something that has never been described before, right? I mean, this is a new invention. This is something new. No one has ever described this before. So when you're drafting it in English, it's quite difficult to get the wording right. And so when you're translating it into another language, you've got to be really careful. It's one thing translating it into another Anglo-Saxon language, another Latin language, not European, Spanish, whatever. It's another thing trying to translate something into Chinese, where Chinese is kind of a vague language. Doesn't have the precision of English, and so it's really important to make sure that your translation is accurate.
Just to jump in there, I mean, when you say it doesn't, let's not get into a language debate here, but when you say it doesn't have the precision, I mean that's a bold statement. Are the words not there, or what do you mean there?
Well, I mean, Chinese. I mean, I'm no expert on Chinese language, but they have sort of compound words rather than words. It's a bit like German. So a computer is electric brain translates directly. Liberty is an expert on Chinese. She can help us on this. But I mean, Liberty, would you agree? It's it's not quite as precise a language.
I mean, I think there's certain elements where it might be difficult to come up with that exact terminology for a small nozzle or a widget or whatever you're patenting. I think that's where Chinese can sometimes it's harder to get that level of detail into your into your application.
Yeah, so it's just something to bear in mind, really, when you're making your application. Do concentrate on the translation, and don't just go with the cheapest quote. I guess is the point
I think
to
that's
make.
A very important point that people need to know. Thanks. Yeah.
Because you will come a cropper later on. So just a quick rundown of the terms. The same as in Europe. So an invention patent, which corresponds to a European patent, you get 20 years. Utility model and design patents, which correspond to our design rights, more or less, you get 10 years. So I think that is everything on patents. If we move on to trademarks, trademarks are at a very basic level. A trademark is a mark of origin. It tells the consumer that where the product came from. So as opposed to a patent or a design protects the shape of a product. A patent protects the inherent technical quality of the product. A trademark simply tells the customer who made it. So famous ones are Apple or Samsung, whatever. I probably don't need to talk about too much more about exactly what a trademark is. You should have them already. I saw 50% of our poll had registered their rights, so I'll assume you know a bit about that. Again, translations are important. Often you'll find in China that the Chinese will come up with their own name for your product, or their own version of your name if you don't.
For those listening, that's our weekly fire alarm. It goes off for about 5 seconds here in the office, I hope. And so just give us a second and that should disappear. It's a little louder than usual this week. And I think we're back. Sorry about that. The world is not ending here in London.
So it's important to come up with your own sort of Chinese trademarks. Things to bear in mind about registration. If we move on to the next slide. The classes are the same as the rest of the world, the NICE classification with the various subclasses. So if you've spoken to a trademark attorney, you'll know there's classes up to, I think there are 40 or so classes. You do have to be slightly careful with the subclasses. I had one client who, a mobile phone maker, who had registered their trademark in China in the sort of the corresponding class to their registration in Europe. And that class in Europe covers mobile phones, but they found that, unfortunately, the same class in China does not actually cover mobile phones. So we had a mobile phone making client who did not have, they had a trademark in China, but one that didn't cover mobile phones. So, you just got to be careful, make sure that you do have the right subclass.
I have a question here from Susan, and she asks, do you need a Chinese legal firm to do this, or can you do it from the UK?
To register your marks, to do the actual registration, only a Chinese firm can do that, but there are a number of firms, including my own, who are happy to do the sort of coordination for you. I mean, if you've registered in England, you will have used probably an English trademark or patent attorney. They, I'm sure, will have best friends in China who they would instruct for you. So you can go ask your European patent trademark attorney to do it for you, and they will arrange it. You can go, of course, go direct to a Chinese attorney, but it depends how confident you are.
Okay, while we're on this topic, and I think this will pop up and has a couple of questions, Arlette asks, what about doing it through the Madrid Agreement?
I think that's possible. I have to confess, I'm actually more a patent lawyer than a trademark lawyer, so I know a bit about trademarks, and yes, I think you can do it through the Madrid. Yeah, Liberty's nodding. Yes, Liberty, do you want
to jump in?
Yes, so the Madrid Agreement is China.
Perhaps you could introduce very briefly what that is in case Hello, I think we should be back now. Yes, sorry, Liberty, start again.
Okay. Hello everyone, sorry about that. So the Madrid Agreement is an international agreement which China is part of to file trademarks, and because they're part of this agreement, when you can file an international application and then select which countries you wish to designate. And if you select China, you will end up with a trademark in China, providing there are no problems.
Good.
Thank you.
Thank you, Liberty. Now, and it's very important, I would say, to select China, because China is a first-to-file jurisdiction. Now, what that means is that the first person to file a trademark in China is the owner of that trademark. Now, you might say that's obvious, but actually, in England, we have a slightly different system, whereby we have a sort of our common law system permits you to sort of claim ownership of a trademark through use. So you don't actually have to have registered your mark in England to be able to claim it. In China, that's not the case. You've got to file it, and if you don't file it, someone else may well do so.
Is that process going to change? I mean, there's a lot of talk about this particular issue, the danger of this first-to-file process. Are there policy changes or things that on the horizon where that might see the situation more aligned with how we do things here?
So I think the first-to-file system is a fairly key part of the way the Chinese system works, and there aren't any current plans that we're aware of to make those shifts. But some of the changes that came in as part of the changes in the trademark law in 2014 have changed some of the sort of little elements of the trademark law that people have problems with. So I think Tom might mention bad faith trademark applications, which is one element that UK companies often experience issues with, and that's basically when, because of this first-to-file system, they arrive in China wanting to register their mark, and a Chinese company has already registered it. And we hope that going forward, the changes in the trademark law that came in last year mean that it might be slightly more difficult for companies to do that.
Okay, thanks very much.
Yes, so that is, as Liberty said, the main danger. You get there, you find someone else has registered your mark in bad faith. If we go on to the next slide, please. So the process for application, I think we probably don't need to go through in great detail. Absolute and relative grounds says absolute grounds for refusal of a trademark are things like same as in Europe. If it's a descriptive word, then if the mark describes the product that you're trademarking, you can't have it. Relative grounds, if it's too similar to someone else's for a similar product, you can't have it. The process is very normal. It's you have a 3-month opposition period, and it's in that opposition period we look at this what Liberty touched on, the change to the trademark law now requires that trademarks should not be registered in bad faith, or they should be registered in good faith. And what that means, well, in the past it was very difficult to, so if you got to China and you found that someone else had registered your trademark and you wanted to fix that problem, you wanted to claim your trademark back, really you only had two options. A trademark can be cancelled for 2 reasons. Firstly, if it was applied for in bad faith, or secondly, if it had not been used for 3 years. And generally, you had to go with the 3-year non-use. Clearly, what we used to refer to as trademark squatters, but Liberty tells me I'm not allowed to call them squatters anymore.
Oh, we got PC about IP now.
Yeah, apparently, yeah. So usually someone who's registered a trademark in bad faith is not going to be using it, right? They're not going to be applying it to any products. They're just owning, they just have the certificate and they're waiting for you to come along and make them an offer. So 3-year non-use, generally you just have to wait for 3 years and then you can apply to the trademark office and say, look, these people have not been using this mark and it should be cancelled. The other way was to try to prove that the mark had been registered in bad faith by the third party. But that's actually really quite difficult because you have to prove some sort of commercial link between that third party and you. The bad faith application, bad faith cancellation only really worked when you could prove that this was the person who registered the mark was maybe used to work for you, and used that sort of inside knowledge that you didn't yet have a registered trademark to go off and take advantage of it. Now, the change to the trademark law has sort of brought that bad faith, or good faith rather, requirement into the application process. But I think the actual difficulty of proving good faith hasn't really changed. So we'll see how it pans out. But
okay. I'm conscious a little of time now, so we'll just move along
yes.
if we can. Yeah.
Sorry. Yeah. Okay. We'll probably skip through this one. We've talked about design and patents really. Copyright we can talk about very briefly. Copyright, same as most countries in the world, arises automatically. You can record it at the National Copyright Association, and this is advisable. If copyright is important to your business, I would record your copyright at the NCA. You don't have to, but it makes proving ownership an awful lot easier. The problem with copyright often is not trying to, not proving that someone's copied something. That's easy. You just compare the two things. Its difficulty is proving that you own it. But if you've recorded your copyright at the appropriate office, then that takes away that problem. So if your copyright is important, I would advise recording it. It's pretty cheap, a few £100 or something, and worth doing. So if we move on to enforcement, there are three main options, and we'll talk a little bit about each one. And then there's sort of other aspects, internet, trade fairs, and one I forgot to add there is customs for export. So if we talk through each one, the court system in China, as Liberty pointed out, the IP system is very new in China. The first law was what did you say? 1983. It's not just the IP system that's new in China, it's the whole sort of legal system. Private law firms were only permitted in the early 90s. So the whole sort of legal system is all not as robust as the English system, you might say. There are three main bodies that will help you enforce. There is administrative actions, civil litigation, and the police. We'll talk mainly about administrative and civil. So we have the administrative actions. Now, what do I mean by an administrative body? This would include the AIC. So each town has something called the AIC, which stands for
the Administration of Industry and Commerce.
There we go. And this is a bit like sort of Companies House in England. It is this, a bit like Companies House. Another administrative body is the Intellectual Property Office. So if you are looking for an admin action, basically you file your complaint at the IPO for patents or the AIC for trademarks, and they have sort of fairly rudimentary powers to raid factories, premises, and seize and destroy infringing items. And they can issue an injunction, and they can levy fines. And they can also mediate settlements between the parties. Now, they're fairly rudimentary, I say, because they're not sort of IP experts. The IPO are, you would have thought, IP experts, but they're not sufficiently sort of sophisticated to make a decision as to whether, say, an invention patent has been infringed. So you generally would use the IPO for design patents. You'd use the AIC for trademarks, for sort of fairly easy to ascertain infringements. And the advantage, if we go on to the next slide, they're fairly cost effective, they're fairly efficient. Once you filed your complaint, they will take action fairly promptly. And you can, and that's fine for a sort of design or a trademark. If you have an invention problem, like I said, they're not going to give you an injunction. They're probably not going to decide on infringement of an invention, but what you can do is use the AIC or the IPO to gather evidence. So you can go to the IPO first, you say this factory is infringing our invention patent, could you please do a raid? And they will be able to go and raid and seize evidence, and you can then use that evidence to be transferred into a civil court action. And this sort of avoids the problem of having to use a notary public. I won't get into it now, but the sort of whole evidence collection process in China is a lot more long-winded and a lot more complicated than it is in England. So if you can use an admin action to short-circuit that evidence collection process, then it can be good. If we go on to the next slide. Problems with administrative actions, idiosyncratic. Yeah, I mean, as I said, it's the local AIC and the local IP office. So if you're in a sort of small-ish or less sophisticated sort of a place, they may be reluctant to take a decision as to infringement. Even on a trademark, if it's not a totally clear-cut counterfeit issue, then the AIC is going to be less confident in coming to a decision than a court might. So you kind of...
And do you have to go to... So if the infringement happens in town X, you can't just turn up in Shanghai and go to the courts there, where you might feel a more transparent or predictable process? Do you have to then do that in town X, wherever that might be?
Well, the rules are the same as in Europe. You can sue a defendant either in its domicile, so where it's based, or where you found where the tort occurred, where the infringement occurred. So in theory, if you find products made by the factory in village A, if you find those products in Shanghai, you can buy them in Shanghai and then bring a case in Shanghai, in theory. However, I wouldn't always advise that, because you're going to come across jurisdiction challenges. So if you sue them in Shanghai, the company is going to say, oh, well, that's not the correct jurisdiction, you should sue us in our hometown. So that's going to add time and cost and delay to your case. You might still win, but you might not. So the next problem will be that if the court wants to go and inspect the factory, which you probably will want the court to go and do what we call an evidence preservation order. So you go to visit the factory, seize evidence, have a look. A Shanghai court, I'm afraid, will not travel to Wuhan, whatever it is, to go and have a look at the factory. So really it's best, in theory you can sue in other places, but in practice it really is best to sue the defendant where they're based. Which means you then are dependent on the local IPO. So other disadvantages, running short of time, you don't get any damages. A fine might be levied, but no damages awarded. That you might the IPO or the AIC might mediate a settlement agreement, in which case you will get some payment, but that's not guaranteed. If we move on to the next slide, we can look at the court system. So the court system, the main thing to bear in mind really is it's a civil law system. It's not common law, so it's a very different system to English. As I said at the beginning, the main problem is evidence collection. In England, the court will basically works from the starting point that people are telling the truth. So if you sign a declaration, you sign a witness statement, the court will take that witness statement as truth unless a barrister proves that you're not telling the truth through cross-examination. In China, they basically start from the starting point that you're lying, and the only person that is telling the truth is a notary, a Chinese notary public. So to collect evidence, you really have to have a Chinese notary public coming with you to buy products from the factory, and the Chinese notary public has to write up a witness statement saying that I went with X to factory A, I saw him go in, and then I saw him come out with the product and a stamped, chopped invoice, etc. So it's a rather different system. No doctrine of binding precedent, which means you get slightly inconsistent decisions. So just because you win your case in Zhengzhou doesn't necessarily mean you're going to win in Shenzhen. There's sort of a bit of inconsistency. 4 levels of courts. You can appeal all the way up. Basic People's Court you wouldn't usually go to. For a patent or a trademark action, you'd start at the Intermediate People's Court. New from last year is there's going to be new intellectual property specialist courts in Beijing, Shanghai, and Guangzhou. So it's going to be specialized IP courts. Their jurisdictions currently are quite small, limited to those 3 cities. But I think the plan is that if they're successful, then they will be rolled out to the whole country. And hopefully that'll introduce a bit more IP specialism into the courts. At the moment, China doesn't really have specialist IP judges. It's all a bit, a judge might only be in the IP court for a couple of years, which is not really long enough to get a sort of full understanding of patent or trademark law. So if we move on to the next slide, remedies are better than in a administrative action. So if you've got a sort of a more substantial case, you'd want to go to court because you can get damages. You can get the court has a bit more power in terms of seizing and destroying goods. It's a bit slightly more substantial organisation than the administrative bodies we talked about earlier. So if if your case is more than just counterfeit, you probably want to go to court. We'll move on to the next slide. Is just very brief timelines. Chinese litigation is quite swift, 6 to 9 months, probably from collecting your evidence through to the hearing. It can take a little while to get your decision, depending on on which city you're in. Shenzhen is notoriously slow. I've had to wait a year for a decision in Shenzhen. Other cities are quicker. It really depends on the workload of the judges. Last slide on litigation. Injunctions. Interim injunctions are something that Liberty and Tom Duke have been working very closely with the Chinese courts on, trying to persuade them that interim injunctions are a good thing. I believe they're very, very important, partly because the damages awarded by Chinese courts are so low that really they never compensate for the damage done to an IP holder by the infringement. So if interim injunctions were given out more readily, then the damages wouldn't really matter because less damage would have been caused. So we're hoping that the Supreme Court is about to issue a new guidance on interim injunctions, hopefully this year. And so hopefully that's they're going to be a bit freer with them, but we will see.
Fine. Keep going. Yeah, we're okay. Don't worry, I'll press the magic trapdoor button if you're going on too long. I haven't done that yet.
All right. So, so interim injunction is very rare, but you will generally get an injunction at the end of your case. So the system is sort of, it's not perfect, and there are things to look out for. But all things being equal, you should be able to get an injunction in a year or so if someone is infringing your products. I'm not going to go into these bits about stays and 2 tiers right now. On the next couple of slides, I'm only very briefly mention that there are criminal sanctions available for IP enforcement, but basically it is up to the discretion of the PSB, of the police, and trying to persuade a policeman that he should be spending his valuable time and energy enforcing your trademark is a challenge generally. So that is very unusual. So we get to the last slide, just to sort of a recap and a few pointers. So next slide.
Next one, yeah, sure. Okay, so these are just some kind of immediately do some pointers for people. Great.
Just a few pointers. The first thing and the most important thing is to register your rights. I can't emphasize enough how important it is, particularly with trademarks, because if you don't register your trademark before you go to exhibit, or even if you've never been to China, these bad faith applicants just spend their time sort of surfing the net, looking up foreign trademarks, which they then register. So you really, if you have plans to go to China, you've got to register your trademark. Otherwise, you'll have to wait the 3 years to apply to cancel for 3 years non-use. Then the other things really are sort of due diligence. Make sure that the people you're contracting with, make sure your contracts set out what you expect them to do and what steps you expect them to take to protect your IP. Make sure the people you're contracting with are reliable. Make sure that employment contracts that you have with your managers, etc., are watertight in terms of trade secrets, in terms of know-how. Make scheduled and unscheduled visits to your operations in China. Don't just assume that it's all going all right. Assumption is the mother of all errors, shall we say. And then other things. So internet, Liberty touched on internet very briefly earlier. Alibaba and Taobao are, as we all know, massive online marketplaces. Alibaba is, in the old days, the sort of Canton Fair, the trade fairs would be where these infringing products are mainly sold. These days, Alibaba is a very major conduit. Luckily, Alibaba are quite keen on IP protection. They have a team who are quite helpful if you make a complaint. There's a sort of online complaints platform that you register your rights and you register your complaints on. I believe last year they took down 110 million links to infringing products. So they're quite proactive, but you have to be proactive. You've got to patrol, you've got to monitor, surf Alibaba, find infringements, and make the complaints.
Yeah, I think last year the CBBC signed an MOU with Alibaba specifically about this, where we would sort of give information to our members about how to go through this takedown process.
Yeah.
They've made a good PR job of wanting people to know that they care about these things, and I think our members have received that well, and we also hold a yearly roundtable with them to discuss any issues, just as a bit of background for that.
Yeah. So it's well worth using the CBBC help on that. If it's all still too challenging, then speak to your lawyers. They'll be happy to help you out with it.
Speak to your lawyers. Speak to your lawyers and accountants. It's an important life rule. Great.
Absolutely.
Well, one thing I would ask, and we're just if you have any questions, please type them in, guys. I do have a couple to ask. The first thing I would ask both of you, Tom and Liberty. So imagine that some of our listeners today are maybe a company with a product who are looking at China. What would be the first 2 or 3 practical things, if they've done none of this, if you know what I mean, if they're looking at this as a blank slate, what would be the first 2 or 3 actual practical steps? Like who do they need to call or who do they need to talk to start the process of protecting their IP?
If they're looking to sell into China, well, the first thing is the trademark. Assuming they have a trademark, the first thing is to go onto the Chinese trademark register and check to see that no one else has already registered their mark. Assuming...
And is that somewhere they can look at in English, or I'm getting real nitty-gritty here. Like
nitty-gritty.
They're typing in a URL. Are they able to do that, or do they need a Chinese speaker to go through it? That kind of thing.
Yeah, I mean, you can try to do it yourself, but it's probably, if you want to be sure, then it's best to get a Chinese trademark agent to do that search for you.
Okay.
But I mean, most agents, I should think, would not charge for that. It doesn't take long. It depends on your agent. You speak to your English trademark agent, you say, can you do a check in China? They should be able to sort that out for you. So first thing is to check that no one's got it. Second thing, then, assuming no one's got it, is to register your own. Then depending on how you're selling in China, I mean, presumably you're going to have some sort of distribution agreement with a retailer in China. So you need to make sure that distribution agreement has points relating to IP. So you've got to make sure your distributor is not going to be going off and selling your trade secrets to other people. You need to make sure they're reliable and have that protection in your contract.
Okay. Anything you'd add, Liberty? Or
no, I totally agree with Tom's points that the best cure is always prevention.
Yeah.
So we always encourage people, the first step you take really to register your IP in China and to make sure you don't end up in that position where you're there and someone else has registered your trademark, because it is that additional level of hassle that we don't think you need.
Yeah, yeah.
Yeah, I've got a question here then from Peter. I think it's one that comes up. Does a confidentiality agreement with a potential client in China protect IP, which is then shared with them? I mean, it's the $64 million question, I guess, to some degree. But you know, how would you advise or recommend in that?
I wouldn't. I would definitely sign a confidentiality agreement, but I would not rely on it 100%. I really, particularly if it's something to do with your if you're relying on a confidentiality agreement to protect something that could be protected by registration, if you see what I mean, then I would always go registration, not agreement. You know, as I said, the whole legal system in China, it's not just the IP system, the whole legal system is not that sophisticated. So a confidentiality agreement has got to be really very precise as to what's being protected. And even then, you know, trying to enforce a confidentiality agreement, you've got to prove that the information was in fact confidential. You've got to prove that it was transmitted in circumstances of confidentiality, which you can do with the agreement, but as long as the agreement details everything that was said to be part of it. So it's, you know, the answer is sort of yes and no. Yes, I would do one, if only for show, but no, I probably wouldn't place whole 100% reliance on it to protect you.
So I think that's the sort of lawyer's end of the story, and the side that you see that the negative outcomes of a lot of these agreements. But we do find that there are companies operating in China with business partners who have protected their IP and who use the registration system effectively, and who also have trusted business partners. And it doesn't mean that you should always rely on a handshake. If you, as Tom said, if you can use the registration system, that is the best option. But there are positive outcomes, and people do operate effectively in China as well.
Yeah, absolutely. I'm not. I'm not saying you can't. I'm just saying, you know, it's a. Yeah, we'll leave it at that.
No, fair enough. Fair enough. No, we're not. We won't be bashing lawyers or anything. No. Okay, so just a question that's from Mary here. I'm going to sort of paraphrase her a little, but it's essentially about getting IP back by like avoiding court, shall we say. So if somebody holds your IP and you don't want to go through the court process, how do you negotiate, or you know, how would you advise people to do that if you haven't registered or can't enforce?
So you mean if you get there and someone has already registered your trademark,
yes,
then it's just a matter of negotiation. You know, you instruct your lawyer to approach their lawyer, or you can go direct, depending on how confident you are. And you know, you've got to name your price. Generally, a trademark that has not been used by the third-party applicant, you know, I mean, they're just in it for the money. So they might ask for £1,000, £2,000. I think the last one I did, they held out for £10,000 to transfer the trademark. So I think, you know, something like that for a not a world famous, you know, mega mark. Obviously, Apple, I'm sure you all heard that Apple had terrible trouble with the iPad trademark due to various contractual errors, should we say, and due diligence errors. It turned out that Apple didn't actually own the iPad trademark in China.
I think, sorry, just to jump in, I think it's an important point there that even companies of that scale can make an absolute hames of it.
Yes.
So, and this is how significant it is and how important it is.
Exactly. I mean, Apple ended up having to pay $60 million to get their iPad trademark back in China. So that's the sort of range. You know, it might only be a few £1,000s. But if you're Apple and you've somehow not got the iPad trademark, then it's many millions. But it's just a matter of negotiation, you know. I mean, and when you get there, you can see when it's been registered. So if it's 2.5 years ago and hasn't been used yet, then you might as well wait for the 6 months and apply for a 3-year cancellation. But if it's, you know, it was only registered a month ago and you're going to have to wait for 3 years, then you might as well open negotiations and bite the bullet.
Great. Okay, well, I think we're kind of approaching our hour there. Liberty, perhaps you could sum up again a little bit from the IPO and from perhaps the government's perspective. What help is out there, and for companies in IP in China?
So there is a lot of help available, and one of the best things about the IP attaché and the services that he provides in Beijing is that it is free. So he is a China expert and has a lot of knowledge navigating the Chinese IP system. So whether you're experiencing a problem currently, or if you want to sort of make sure that you have the best mitigating strategies in place, our attaché in Beijing, whose name is Tom Duke, and his email address will be available online, links to the
Yeah,
webinar.
I mean, Tom speaks regularly enough on our webinars, but if anybody wants to get directly in touch with Tom, please do contact me. You'll find my email address on all the little invitations that get sent out about these webinars, so please do contact me. I'm happy to put you in touch.
Yeah. And as well as our attaché, also online, I mentioned the fact sheets that we have, which are a good introduction and an overview. So sort of a lot of the messages that we've talked about in this webinar are there in the fact sheets, which we produced together with CBBC on gov.uk. So if you look for UK-China intellectual property, they'll be there with some detail. And as well as that, we try to do as many events in the UK and as China as possible. So keep an eye on the IPO Twitter account, where we try and publicise upcoming events where either myself or Tom Duke, our attaché, will speak and try and answer your questions to the best of our abilities.
Terrific. Okay, well, thank you very much. I think all that remains is for me to say thank you to Tom and to Liberty. I hope this was a valuable session for everybody out there. If you have any questions, any feedback, any topics you'd like us to see, us cover on this platform, please do get in touch with us. Other than that, I wish you all the best business in China and have a great day. So thank you very much. Bye now.